Greetings and a warm welcome to everyone in all parts of the world. I am so happy that you are joining us today. I am Dr. Connie Soban-Sensor, the Chief Representative to the United Nations for the League of Women Voters. The League of Women Voters is a nonpartisan grassroots organization working to protect and expand voting rights and ensure everyone is represented in our democracy. We empower voters and defend democracy through advocacy, education, and litigation at the local, state, and national levels. Today, we are proud to collaborate with the Baha'i International Community and Integrity Initiatives International with support from the NGO Liaison Service at the UN Department of Global Communications. I want to acknowledge Ian Lynch from III and Judge Madeline Mata from the League of Women Voters, and Dan Perel of the Baha'i International Community, who worked together to make this event happen. We have a wonderful group of experts speaking to us today, and you can find their full bios on their websites. I will give a brief introduction and turn it over to our moderator for today, Karen Langdren. Karen, most recently, was the executive director of the Security Council report, where she provided independent analysis on the work of the UN Security Council. She is an expert in the international peace-building community. I will give a brief introduction and then as we come to a close, at the end of our session, Dan will wrap up and offer closing remarks. Grand corruption, just in terms of background, is also known as kleptocracy. It involves leaders misusing public office for personal gain, often stealing billions from the global health and climate initiatives. This drains vital resources needed to meet the UN's 2030 Sustainable Development Goals. And grand corruption weakens democracy as kleptocrats enjoy impunity, use their power to silence the media, control the judicial system, and manipulate elections. Refugees fleeing failed states led by kleptocrats cause international crises. Uprisings against grand corruption destabilize many countries and pose a threat to global peace and security. Women and families disproportionately face the worst consequences of grand corruption. When corrupt leaders rob their country's wealth, child mortality rates increase, access to basic services like healthcare and education is reduced, inequality is exacerbated, and violence from repressive governments and organized crime increases, and fundamental trust in institutions erodes. A movement has emerged for an international anti-corruption court, or IACC, that could fill the enforcement gap in the international framework for combating grand corruption. We are about to learn how the IACC can help deter corruption and return illicit assets to benefit the public good in this hybrid webinar, Corruption, Never Victimless, the Case for an International Anti-Corruption Court. We had intended to record the entire meeting, and we had a little glitch where the introduction got cut off, and so did our first speaker. So I would just like to introduce Serena Ibrahim, the founder of YAC, the Youth Against Corruption, that aims to prevent and control corruption through youth talents, social innovation, and social entrepreneurship. From here, I'm going to turn it over to Karen Langdren and the remainder of our meeting. Thanks so much for joining us today.
Recorded. Thank you again. We're going to turn now to Mr. Casey Michel. He is the director of the Combating Kleptocracy program at the Human Rights Foundation and the author of several books on illicit finance, including the forthcoming United States of Oligarchy. Casey, you've thought deeply about the transnational nature of corruption, the networks that seemingly aren't restricted by either national or international laws and rules. Please tell us more about how this plays out.
Thank you so much, Karen. Thank you so much, Connie. Thank you so much to everyone for being here today. It's an honor to be joining all of you. I want to take just a few minutes during this opening comment to talk about a world that has unfortunately kept me quite busy over the last few years. Very much a growth industry these days, the world of international corruption, kleptocracy. Now, the thing that we have to remember in the 21st century is that corruption is not something that happens in one country, under one regime, or in one place. Corruption in the 21st century crosses borders, crosses oceans, crosses hemispheres, and it creates what we call kleptocracy. Kleptocracy, of course, means literally the rule of thieves. It can be used to describe a single government, a single regime, a single dictator, but in the 21st century, it also describes this phenomenon of all of that stolen money being moved to other jurisdictions, to be hidden, to be laundered, and still to be used by those who are stealing it in the first place for whatever they need. This really is the essence of corruption in the 21st century, how autocrats steal from health budgets, infrastructure budgets, and education budgets, and then turn to places like my beloved United States of America to set up the shell companies and the anonymous real estate investments, venture capital investments, hire perfectly legally lawyers, PR specialists, and consultants to launder both their money as well as their images to keep them in power in perpetuity to continue enriching themselves and their inner circles and their family members. Now, if we had been speaking, Karen, about a decade ago, I suspect I would have had to kind of explain many of these different things, what a shell company is, what money laundering is, maybe even what kleptocracy is. But I get the sense that over the past decade and maybe even the past few years, a lot of folks in this audience and around the US especially have begun to understand what some of these terms are. This is very much a be careful what you wish for scenario on my end. I'm not sure that it's necessarily the reason I was hoping for, why a lot more folks are familiar with shell companies, money laundering, and kleptocracy writ large. But this is the world we now have. Now, we can go into more detail about this later in the conversation, but there is one thing that is still missing from these conversations about corruption and kleptocracy, and that is the victims. Those who are actually missing out on all of this money that is stolen by these ruling regimes that are dedicated only to enriching themselves and laundering as much money as they can. And look, Serena's absolutely right. Everyone is a victim. Doesn't matter what age, doesn't matter what gender, doesn't matter what faith, doesn't matter where you are. If you're living under one of these autocratic regimes, and if you're not inside that inner circle and directly benefiting, you are a victim. But we are here today, unfortunately, to talk about the disproportionate impact on women. Karen, there's a quote that you mentioned about corruption exacerbating existing inequalities, and that's absolutely right. And again, this is the predominant reason that corruption and kleptocracy has a disproportionate effect on women. Look, you can go through the list, and again, maybe we'll talk about more of this later. We know about the links between corruption and autocracy and the disproportionate impact that has on women. We know about the links between corruption and lack of development, which again, directly affects women. We know about the kleptocrats stealing from healthcare budgets, which mean hospitals and maternity wards aren't built. Connie, you mentioned the increase in maternal and child mortality, which is absolutely a reality. We know that they steal from education budgets, which means that girls don't get the education they deserve. And we know that they steal from infrastructure budgets, which makes life harder on absolutely everyone, not least those women just trying to live their lives. Again, you can pick any kleptocratic regime that you want around the world, and you can see this in real time. You can go to Saudi Arabia, where the regime spends billions of dollars on laundering its image, where women remain second-class citizens. You can go to Equatorial Guinea, which still has, at last check, the highest per capita GDP in Africa, but where many, if not most women, still lack access to potable water, and girls lack access to basic education. And of course, you can also go to places like China, where women, and especially Uyghur women, are subjected to horrific abuses by corrupt officials. The list goes on and on. And it is these stories that are all too often overlooked in stories about corruption, which is why, again, I am maybe this isn't the right emotion, but happy to be here today to be discussing some of this with you. And again, especially in places like the United States of America, where so much of this stolen money ends up and is laundered for the benefit of these networks and these so-called enablers in the US itself. So as I wrap up, maybe instead of ending on too down of a moment, I did want to say that it is worth highlighting that a decade ago, if I had to define these topics, a decade ago, these conversations also were not happening. Or maybe they were happening, but in significantly more restrictive and isolated pockets. But here we are today, having these high-level conversations about this, talking about some of the potential solutions, talking about things like the International Anti-Corruption Court. And look, we're not where we need to be yet. Corruption still remains a growth industry, but it is these conversations, these ideas, these shoots of optimism that give me hope that someday I will finally be out of a job and I can do something else with my life. So thank you, and I look forward to this conversation.
Meanwhile, thank you so much, Casey. I'm taking away that kleptocracy is really a parallel system with different interests to most of our interests. And I'm also trying to find the silver lining in the fact that we've become more fluent in the language of both autocracy and grand corruption. Maybe we are having our moment. I want to turn now to Judge Richard Goldstone joining us virtually. Judge Goldstone needs very little introduction. He was the first chief prosecutor of the International Criminal Tribunals for both the former Yugoslavia and Rwanda, and is a former Constitutional Court Justice of South Africa, also a board member of III. Justice Goldstone, and there's a lot more, I encourage you, as Connie did, to read his Wikipedia page. Justice Goldstone, the world has some instruments targeting grand corruption. What would an International Anti-Corruption Court, IACC, add to this? And what would make its criminal division impactful? Over to you.
Well, thank you very much indeed for the introduction, and my deep thanks to the US League of Women's Voters for having organized this important discussion. Let me begin, as it's already been noted, that for many years corruption at the highest levels of government has been pervasive in many countries on every continent. The amounts involved are really astronomical, and greed appears to have no limits. The loss of these funds have seriously and negatively impacted the provision of healthcare, housing, education, and basic infrastructure. It has taken funding from the fight against climate change and exacerbated famine and the deprivation of fundamental human rights. These crimes of corruption impact more victims than any other form of criminal conduct. And as already been suggested, the primary victims are too frequently women and children. It is striking that while the United Nations Convention Against Corruption, UNCAC, has provided a workable framework for domestic laws, there is no international mechanism to investigate and prosecute the corrupt leaders and those who facilitate their crimes, the banks, lawyers, real estate agents, and other financial providers. What is perhaps more important is that there is no international mechanism to freeze, seize, and repatriate the illicit financial flows that amount to many billions of dollars annually. These illicit proceeds are invested in a number of countries, and especially those that have become well-known havens for laundered assets. Grand corruption does not exist because of a lack of anti-corruption laws. No less than 187 United Nations member states are parties to UNCAC. Most of them have enacted the required statutes criminalizing bribery and money laundering. However, some states that are party to UNCAC are governed by kleptocrats. They enjoy impunity in the countries they rule, where they control the police, the investigators, the prosecutors, and the courts. During the past 18 months, Integrity Initiatives International, III, has been drafting a treaty for the court. We have involved over 70 leading international law and international criminal law experts from many countries. We recently produced a draft treaty, which is being shared at this stage in confidence with a group of over 30 interested governments and some leading civil society organizations. Their input will be used to update the draft treaty, which will then be disseminated widely and used for public consultations with governments and civil society. Several countries are committed to working with III towards the creation of the IACC. They include the Netherlands, Canada, Nigeria, and Moldova. Recently, the new anti-corruption policies of the United Kingdom and Norway included commitments to actively participate in dialogue about the IACC. In addition to Nigeria, there are senior officials in other African states that have indicated an interest. They include Zambia, the Democratic Republic of the Congo, Gambia, Senegal, Cote d'Ivoire, and South Africa. There is a vacuum in the mechanisms designed to prevent, disrupt, and dismantle international corruption, and in particular money laundering. So the IACC is designed to provide a competent and efficient means of filling that vacuum by complementing domestic efforts to combat corruption. Its jurisdiction would only be exercised when domestic authorities fail to enforce the existing laws they are already obliged to have as members of UNCAC. The court would have jurisdiction over crimes of corruption committed by nationals of member states and crimes committed in the territory of member states. Perhaps the most novel feature of the draft treaty is its provision for the IACC to have two divisions. The first will be a criminal division that will have jurisdiction to investigate and prosecute alleged kleptocrats, bribe payers, and money launderers, and order the freezing and seizing of their illicit assets that might be found in the territory of a state party. Then there will be a second division, an assets division, which will be explained shortly by my colleague Alan Rock. The criminal division would have the jurisdiction to investigate and indict the kleptocrats and those who conspire with them in the commission of their crimes, and especially in the laundering of illicit assets that inevitably flow from their nefarious conduct. The criminal division will have an important advantage denied to the International Criminal Court, the ICC. The IACC criminal division will have authority to proceed against the assets of kleptocrats, even if the kleptocrats themselves are not physically before the court. It will have the authority and the means of freezing and seizing the laundered funds that are often held in names of shell companies. With this in mind, the court will have jurisdiction over legal persons, corporations, the entities in whose names the assets are hidden. This powerful tool will act as a potent deterrent against corruption and a means of ensuring that the ill-gotten assets at an appropriate time are returned to the victims, the women, children, and men of the countries from which they have been stolen. There is a huge potential for the IACC to become a crucial new tool in the international armory designed to punish kleptocrats and their co-conspirators and to recoup their illicit assets. I thank you for your attention.
Thank you very much, Judge Goldstone. So the IACC would kick in if and when domestic legislation is not effective, and for reasons we've heard, it often isn't, including over shell companies. We're going to turn now to the Honorable Alan Rock, a former Canadian Minister of Justice and a former Canadian Ambassador to the UN. He is the chair of III's Treaty Committee and a fellow member of our Board of Directors. Alan, Judge Goldstone has talked about the criminal division of the proposed IACC and also the proposed assets division. How might that cause or compel the return of illicit assets to serve the public good?
Thank you, Karen. And may I say at the outset that as this movement looks for support at the grassroots around the world, we could think of few more attractive or effective potential partners than the League of Women Voters. The quality of your leadership, the strength of your commitment, the quality of your advocacy, all of that it commends itself to us. So we're delighted to have this opportunity to speak with you about this project and hopefully enlist your support. I'll speak about the two divisions, or the second division of the proposed court, and explain how it will work. Obviously, the the division that comes first to mind is the criminal one, of which Justice Goldstone just spoke, investigating and prosecuting those who engage in grand corruption, along with their enablers, the lawyers, the accountants, the financial planners who make it all possible. But I speak today of the second division of the court, which is the assets division. And that will have authority to deal with property which is involved, whether it's cash, or land, or chattels, which is alleged to be the proceeds of corruption. So that when there is a criminal prosecution, judges of the court will be able to engage the assets division to deal with managing a big building, if that's the property in question, investing cash and freezing it until the disposition of the criminal charges, or other ways to deal with property is involved in the grand corruption. And of course, at the end of the prosecution, if there's a conviction, the assets division will be there to help answer the question, what do we do with the property now? How is it best disposed of in the interest of justice? But as Justice Goldstone suggested, perhaps the most innovative part of this treaty and the new court is a division of the court which will allow the assets division to act independently. And I'll explain what that means. Given the scale and frequency of grand corruption, the amount of money that's stolen every year around the world, we're speaking of hundreds of billions of dollars. It's simply not possible to imagine that in every case there will be a criminal prosecution. We don't have enough investigators or prosecutors or courtrooms to make that happen. At the same time, when the stolen money is frozen because it's identified by a specific country, whether it's Canada, the UK, US, Switzerland, there has to be a way to take that money and return it to the victim state so it can be used for the purposes for which it was intended. Social services, infrastructure, and so on. And here's where the assets division has an independent role to play. In today's world, when money is frozen, I'll give you Canada as an example. Money is frozen in Canada because it can be shown that it's illicit funds that were stolen by the kleptocrat in power in another country. So the court in Canada can freeze the money. And sometimes it sits on the books of that bank for years. And eventually there may be negotiations between the victim state and Canada saying, well, can we have that money back? That becomes a complex and difficult negotiation. Canada is often concerned to know that, in fact, the people we're dealing with are those who are illegitimately in authority. We're concerned to know that if we send the money back, it will just simply be restolen. We're concerned to know that the money in Canada, which is frozen, actually came from the treasury of that country. And so it becomes a combination of the difficulty of proving facts, establishing good faith, and determining what's in the interest of justice in terms of getting that money back to where it was stolen from. And the system at the moment is inadequate for the purpose. It's lengthy, it's slow, it's unpredictable, and often it's unfair. And there's a lot of frustration on the part of victim states who want the money back because they have crying needs for infrastructure and social services, and they cannot get the money back. And Canada wants to give it back. I mean, we're not in the business of using stolen funds to fund our services. The banks where it's frozen want it off their books. So here's where the assets division of this court comes in. It will provide an impartial, independent forum of experts who will receive and consider and adjudicate upon these questions of who should get the money. We'll receive evidence. Judges will hear the evidence by the victim state, showing that it came from their books. Canada will respond, ask whatever questions we have in our mind. A judge will consider all the evidence and make a determination, and do so on the balance of probabilities, not beyond a reasonable doubt. So this is the civil standard of proof. So it's accessible, not impossible. And in that process, we hope to have a transparent, clear, predictable, accessible, and just way to dispose of and return these assets. So The treaty that has been drafted, to which Justice Goldstone referred, has extensive provisions describing how the court in its assets division will exercise this authority. It will have the authority to deal with exactly this type of case and relieve the frustration of victim states who've been waiting an awfully long time to get the money back. Relieve those officials in countries like Canada who want this issue resolved in a fair and just way, and put the money to work where it belongs, back in the country from which it was taken. So that, in sum, is what we're proposing. And we're finding as we go around the world, I was in Doha, in Qatar, just a few months ago at the Conference of State and Parties of the United Nations Convention Against Corruption. And of the countries I spoke to about this, there's a lot of enthusiasm because they recognize the crying need for this kind of mechanism. Recourse by victim states to an independent, impartial tribunal to apply its expertise in investigating, evaluating, and deciding in a summary way these sometimes complex questions of who should get the money and on what terms. So I'll leave it there and happy to answer any questions you may have. Thank you, Karen.
Thank you so much, Alan. The Assets Division and its independence sound enormously innovative as an element of this draft treaty. Let me turn now to our final speaker, Ms. Rebecca Schutt, who is the co-convener of the Washington Working Group for the International Criminal Court and an international lawyer who has worked for many years on campaigns for democracy and human rights worldwide. Rebecca, how do we go from this draft and the vision for an IACC to actually building a movement and making the court a reality, especially in today's pretty harsh context?
Thank you so much, Karen, for that penetrating question. And thank you to the League of Women Voters and the high international community for making this conversation possible, especially during such a busy 2 weeks with the Convention on the Status of Women and side events. It's certainly a privilege to join this discussion and follow such distinguished speakers. And we've already heard powerful reminders today that corruption is never victimless, from the lived experiences shared from Lebanon to the global patterns of kleptocracy documented across regions, to Justice Goldstone's reflections on institutional accountability and Honorable Rock's insight on how new mechanisms to ensure asset recovery and stolen funds are returned to benefit the public good are achievable through an international anti-corruption court. So rather than repeating these compelling accounts, I would like to briefly underscore one dimension that should remain central to this conversation, and then turn to the subject matter of your question. I would like to underscore a little bit, given the events that bring us together today, the occasions that bring us together today, the gendered consequences of ground corruption. And then I'll turn to the coalition building strategies that are needed to advance the International Anti-Corruption Court and turn it into a reality, many of which are already underway. Those who are privileged to be in the room with us have a helpful little handout. And I'm sure these insights and resources can be shared online with those who are not here in person. So to begin, as has been emphasized already throughout, ground corruptions not only distort economies or weaken governance structures, it reshapes the daily realities of families and communities. When billions are siphoned away from public resources, health systems deteriorate, schools lack funding, and social protections weaken. In many societies, most societies, I will say, women absorb these shocks first and most intensely. We carry expanded burdens of unpaid care when public systems fail. We navigate informal and often exploitative systems to secure healthcare or education for children, and face heightened insecurity, where corruption empowers repressive institutions and organized crime. Corruption can also deepen gender equality in more direct ways. When access to services becomes contingent on bribery or patronage, women, who often have fewer financial resources and less political access, face greater barriers. In some contexts, corruption intersects with coercive practices such as sextortation, where sexual exploitation becomes a form of illicit payment. And when kleptocratic systems capture courts, police, and oversight bodies, the avenues for justice that women and marginalized communities rely upon are often the first to disappear. For all of these reasons, the fight against grand corruption is not only a governance challenge, it is also a struggle for gender equality, human dignity, and social justice. But if we look at the history of international justice, one lesson stands out clearly. Transformative institutions do not emerge from legal arguments alone. They emerge from broad, strategic, and sustained coalitions. Which brings me to your question. The creation of the International Criminal Court offers perhaps the clearest example. The Coalition for the ICC united thousands of civil society organizations across regions and sectors. Its success came not merely from its size, but from its strategy, building alliances across movements, coordinating regional networks, pairing civil society advocacy with principled state leadership, and maintaining strong technical expertise throughout negotiations. And importantly, for today's conversation, gender justice advocates were central to that effort. Women's rights organizations worked tirelessly to ensure that sexual and gender-based crimes were fully recognized within the Rome Statute. And I might point out that we're still doing so today in the ongoing negotiations for a Crimes Against Humanity Treaty. These examples demonstrate how coalitions can shape not only institutions, but the substance of international law itself. And there are important lessons here for the movement supporting an international anti-corruption court. Successful coalitions first must be cross-sectoral. Grand corruption is not only an anti-corruption issue, it is a development issue, it's a human rights issue, it's a gender justice issue, and increasingly a peace and security concern, as we've heard from our friend in Lebanon most pertinently. The coalition must therefore bring together anti-corruption advocates, development practitioners, gender equality movements, financial transparency experts, journalists, diplomats, and legal scholars. I'm sure I'm leaving some sectors out. Second, the coalition must also be genuinely global. As we've heard, kleptocracy is transnational and its victims are found in every region. Leadership and ownership must therefore emerge from diverse geographic constituencies, particularly from societies that have experienced the devastating consequences of grand corruption firsthand. And third and lastly, these coalitions must successfully bridge the technical and the political. The architecture of the court, questions of jurisdiction, complementarity, and asset recovery must continue to be developed with rigor and care. And I have been privileged to serve on the drafting treaty body, as well as in various other capacities to advance this effort. But here, technical work alone will not suffice. It must be accompanied by sustained diplomatic engagement and a growing community of states willing to champion accountability. And encouragingly, much of this work is already underway. Integrity Initiatives International, founded by Judge Mark Wolf, along with Justice Richard Goldstone, has been instrumental in catalyzing the global movement. And now, under the leadership of Honorable Alan Rock and the dynamic stewardship of Executive Director Ian Lynch, online with us today, the organization is building precisely the kind of multi-stakeholder coalition that successful international justice initiatives require. Convening governments, mobilizing civil society, engaging legal experts, and advancing the technical work necessary to close a profound enforcement gap. Equally important in this investment, and I will end soon, I know my time is close to expiring, is the investment in the next generation of leadership. Through its Youth Leaders Network, the International Anti-Corruption Court Coalition has brought together young lawyers, journalists, technologists, and advocates across continents who are organizing to confront corruption in their own societies and strengthen democratic accountability globally. And their engagement reminds us that the fight against kleptocracy is not only institutional, it is generational. And so therefore, the movement for an international anti-corruption court is about more than the creation of a new legal body. It is about building the architecture of global accountability for an era in which corruption itself has become globalized. So history shows us that institutions of international justice are not inevitable. They are built patiently, deliberately, and collectively by those who refuse to accept impunity as the natural order. As we continue to build the coalitions emerging today across sectors, across regions, across generations, we have the opportunity to transform the global response to kleptocracy, not simply by condemning corruption, but by ensuring that those who profit from it can no longer do so with impunity. Thank you, and I look forward to the discussion.
Thank you so much, Rebecca. And I certainly remember a time when I was told that the Rome Statute was never going to happen, or the Landmines Convention was never going to happen. And here we are. So I really appreciate the discussion of how transformative institutions emerge, and that there are so many potential partners in this struggle, which must be global and must include youth. So thank you again. Thank you all our speakers. We're going to come back to all of you. I want to open the floor to questions. If you are joining us remotely, please type your questions in the chat. We'll take, I don't know, a handful of questions and then turn back to our panelists. We might be able to do a couple of rounds. So the floor is open. All right, we have two questions from our remote participants, which I will read out. And those of you in the room, please also identify yourselves if you take the floor. These are questions from Nazia, defender from Pakistan. Considering that corruption undermines development and governance, how could a global mechanism like the IACC support the achievement of Sustainable Development Goal 16, particularly in strengthening institutions, justice, and transparency in developing countries? And from the same participant, from the perspective of developing countries, corruption often directly affects the poorest communities by diverting resources from essential services such as education, health, and social protection. How could a proposed IACC ensure accountability when national institutions are weak or politically constrained? Important question. The floor is open for other questions and comments. Yes, please.
Thank you very much. My name is Petra Dugard Johnson, and I work with Friends International Ghana in Ghana. When I saw this online, I was very much happy about it. Looking at the various issues we have seen in our own courts around corruption, which really have not had any form of resolution or have been thrown out of the court for various reasons. I'm just wondering if this court is established, who will be able to come to the courts and what would the criteria be? And then I'm also interested in how will investigations be done? Is it going to be done with the national investigative bodies, or is there going to be an independent body from the IACC who is going to do the investigation? Yeah, thank you very much.
Thank you. I saw another hand.
Oh, okay.
Yes, please.
So, thank you. This I'm Nancy the Executive Secretary for the Ghana Exploration Commission. I want to find out, I didn't see Ghana on the list, so I was wondering why Ghana is not there. So I'm hoping that we'll try and get Ghana on the list. And I am interested in the crypto, especially in the asset management. We have now new forms of assets. When you talked, you spoke about money, but now we have moved from money and investments in banks. So how is the ICC positioning itself in the new investments that people are using to hide money? And also, how about offshores that, especially people from our part of the region, use a lot of these countries that do not align with international treaties or IIFFs in terms of even sharing information in asset tracking and all that. So what are some of the mechanisms we are putting in place? Because even now, asset tracing is still a challenge. So what are we doing to ensure that these things are put in a proper context so that it's easier to trace assets and be able to manage them?
Thank you. I'll take one more for this round, please.
Yes, I have a question around the jurisdictional, Jean Witherspoon, League of Women Voters. And I have a question around the jurisdictional concept of a framework. In other words, I can foresee disputes between courts and court systems in different countries over who would have jurisdiction, both as to the individual corrupt individuals, allegedly corrupt individuals, as well as the assets. The country, perhaps the US in its civil asset forfeiture actions would say, we've got an action pending against that boat, that house, that piece of land, that bank. So how would these jurisdictional components, how are they, I guess, what's the framework for them in this anticipated court and draft?
Thank you. I think we're going to pause there to get some answers from our panelists, because these were very meaty questions about national, practical, and political constraints. Who can come to the courts? How will investigations be done? Non-monetary forms of assets, offshoring, and jurisdictional questions, including jurisdictional clashes or potential clashes. Speakers, let me ask for volunteers who would like to take any aspects of these questions. Alan, I see you.
Well, I can start if you'd like, and then I will need the help of others on some of them. But let me start with some of those that fall within this topic that I dealt with. First of all, who can come to the court? It's a court that is seen to be at the service of states. So as a citizen, I would not be able to go to the court and invoke its jurisdiction. We will have protection for whistleblowers. So if somebody knows that someone's stealing money or has taken a bribe, acted corruptly, they can share that information with the investigators. The treaty will have provisions to protect whistleblowers. The information they provide can be used to start or to accelerate investigations, but access to the court is by states. That having been said, when the Assets Division is worried about what to do with a sum of money on deposit in Canada, should it be sent back to country X, it will also concern itself with individuals who may want to come forward to intervene and say, wait a minute, that money is in that apartment building, but I have a mortgage against that apartment building and I'm entitled to be repaid the mortgage. And the court will look at whether that person acted in good faith in advancing money on a mortgage, was not aware that it was corruptly acquired, and their interest will have to be taken into account and respected. So there will be an opportunity in the Assets Division as it sorts through what is a just outcome for the return of money to take into account the role of individuals who may have an interest in good faith as well. Turning to the question of who will be doing the investigating, it has to be, certainly on the criminal side, they have to be independent investigators. If you think of a country in which, and the country for which the criminal court we propose to create it, it's a country run by a kleptocrat who controls the police, the investigators, and the courts. So that person is not going to be prosecuted because they control the whole system. There are many countries like that that are captive in the hands of kleptocrats. Makes little sense to ask the police or investigators there to amass the evidence. It has to be an independent investigation. One of the challenges that they will have is getting access to the evidence. And that continues to be a challenge. But the provisions in the treaty and the capacity of the investigators that we envisage will be able to meet that challenge. There are agencies out there today, including journalists, who track down and trace funds, and publish links between money on deposit in Panama, for example, and politicians in various countries around the world. The links are there. It's possible to unearth them. And with you combine that with subpoena power on the part of the court in a criminal investigation, we're confident we can overcome the challenges of gathering evidence independently to support prosecution. Obviously, if the evidence cannot be put together, then we will not be able to persuade the court to lay the charges. Among the other questions that were asked, there is a sophisticated worldwide web to assist people in hiding this money. There are places that come to mind, I won't name them, where we readily imagine that money could be on deposit or assets could be held. Some say, well, you know, we won't find it. But the Panama Papers, published a few years ago, demonstrated that indeed you can find it. And once you do find it, then I think the resorting to the international network of police, prosecutors, and governments who are cooperating with the court can assist in advancing the prosecution. You point out that money is held in various forms, sometimes in cryptocurrency, which can easily be disguised. That too is a challenge for the court. But again, we're confident that we can meet it. There's a group in Washington, D.C. called Sentry, which undertakes investigations of illicit funds. And we visited them in the course of preparing the treaty. They demonstrated how they were able to trace money stolen by the generals in South Sudan into apartment buildings and office buildings in Nairobi, Kenya. The tracing was done so thoroughly that they had documents that were in a form that could be put before a court if indeed a court existed to receive them. So with modern investigative techniques, tracing the trail left behind when money is transferred and appears in the form of various assets, sophisticated investigators today are able to follow the trail and unearth the evidence. So we're confident it can be done. I should stop there. There are other questions that arose and others maybe.
I think Judge Goldstone has his hand up, so we'll turn to you. Judge Goldstone, you have the floor.
Right, thank you. If I can just respond briefly to a couple of the questions, and they were very good questions that have been put from the audience in New York and online. The first point I would make is that we who are involved in III with this project to set up the International Anti-Corruption Court are convinced that it will have at least three positive effects. The first is that it will help to restore the illicit funds that have been stolen, will help to restore them to their true owners, the victims of the countries from which it comes. And obviously the assets division of the IACC will only send that money back at an appropriate time. The money obviously won't go back to those countries while they're still ruled by kleptocrats. But it's important that the assets division will be able to invest those funds, look after those funds, and ensure that they are restored at an appropriate time. The second effect will be to act as a deterrent. We know that kleptocrats never keep their money at home. It's too dangerous, and they don't know how long they're going to be in office. They don't know how long those assets will remain available to them. So they launder them in a number of countries. And it's important that the countries where monies get laundered should join the International Anti-Corruption Court. That's crucial. I take, for example, the United Kingdom, which is, as I've indicated earlier, is very interested in the International Anti-Corruption Court. It's notorious that millions, if not billions, of British pounds worth of illicit assets are invested in properties in some of the fanciest areas of London and other parts of the UK. So if the UK joins, It will make those assets vulnerable to being seized and attached by the International Anti-Corruption Court, and that will act as a deterrent, certainly in some cases, against corruption. The third is that the court will be able to assist smaller countries, countries that don't have the resources, the physical or the financial or the personnel resources sufficient to really go against corruption on an international basis. It's the reason that a country like Moldova is supportive of the International Anti-Corruption Court, because they're aware that the expertise of the IACC, its investigators and its experts, will be made available to smaller countries to enable them to do the work themselves without necessarily using the courts and the judges of the International Anti-Corruption Court. So I hope those begin to answer some of the questions that have been put.
Thank you. Casey.
I was just going to say, just to build on Barak's comments a moment ago, one of there's two kind of clear realities in the world of offshore finance and kleptocracy that have been true for years and are true regardless of the network or where we are in terms of anti-money laundering policy. One is that the demand for these money laundering and offshoring services, that's not going anywhere. These regimes are always going to be looking for another jurisdiction, another country, another laundering service, whether it's United States of America, United Arab Emirates, whether it's the crypto industry, what have you. They're looking for those because they want the secrecy to make sure that no investigators, no tax authorities, no journalists can ever find, can ever trace and track that money back to its origins. That's the underlying reality of the demand side and the supply side of the offshoring world. Now, there's also a flip side to that, which Honorable Rock mentioned a moment ago, that these networks are inherently international, inherently transnational. I mentioned the Panama Papers. It's been 10 years since the Panama Papers came out. I was so much younger when that first happened. There's one reason that happened, because it was a whistleblower. And so to have whistleblower protections for something like the IACC is absolutely clear. But the reality is, what that illustrates is that these transnational networks, all it takes is one loose element or one signatory to the IACC, however that may actually end up playing out. And suddenly you get insight, maybe not every insight into every part of that path, but you get an incredible insight into how so many of these networks are operating. I don't remember off the top of my head if there are any Canadian officials in the Panama Papers themselves, but there were officials from Iceland, from Pakistan, from the United States of America, from the United Kingdom. The list goes on and on and on. And that was only one whistleblower in one law firm in one country. Look, none of this is a panacea, but the transnational element offers opportunities to have one weak link be able to open up and get us insight into that. I would love to have plenty of weak links and insights into that, and I would love to have Ghana as a signatory. It's a charter signatory for IACC when it goes live. But I'll just stop.
Thanks. One thing that strikes me before I give Rebecca the last word of this round is, I think not enough opprobrium, not enough shame attaches to offshoring facilities. We know that it continues. Only the Panama Papers, what was the other one? The Paradise Papers.
And the Pandora Papers. They're running out of alliteration.
Well, we haven't even exhausted the P's yet, I think. So how to make clear that this practice of offshoring isn't just bureaucratic, but it's really shameful and unacceptable internationally. I think we have a grassroots effort on our hands in that regard. Rebecca.
Thanks. So just piggybacking on some of the comments of my esteemed colleagues. So Casey, yes, it only takes one weak link. It only takes one willing party. And when we talk about the multiplicity of states that are engaged in one transaction, one corrupt chain of events along that pathway, one would hope there would be a state party to an IACC, which brings me to some of the questions around potential clashes of jurisdiction, questions of complementarity, etc. So in terms of complementarity, I think we all basically understand the bedrock principle that an international court such as the IACC intervenes when a state is unwilling or unable. We've talked, Justice Goldstone brought the example of Moldova. where this is often not an admission of some deficiency, and it is not necessarily a pointing of guilt from another side. There's also something called the principle of reverse complementarity, where international courts and tribunals are very helpful in building up domestic systems. You're seeing this increasingly with the International Criminal Court, for instance, and you see concurrent pathways to justice for some of the crimes in front of the ICC. Actually, just today, the appeals chamber found that the proceedings in the Central African Republic were sufficient to meet the requirement of complementarity for a potential defendant there. And that would not have been possible, I think. I'm editorializing here, but when the car situations first came before the ICC. So what we hope with an IACC is over time, the domestic frameworks will grow and will be better able to handle these sorts of claims. At the same time, when we look at complementarity as maybe a vertical sort of relationship, up and now down, we're talking about reverse complementarity, we also look at cooperation. And we're increasingly seeing international courts and tribunals seized of similar issues, potentially with different subject matter jurisdiction, potentially with different personal jurisdiction, such as when we have intertwined crimes in situations from Myanmar to Ukraine to Sudan, you name it. Almost always these have corruption aspects. So it will be absolutely essential for the IACC to cooperate with other international courts and tribunals, as well as the regional systems as well. And then to come back to the point, that the first factual point that Honorable Rock answered about who can appear before the court, just because this is a court that is meant to be availed of by states, doesn't mean we should lose sight, I think, of the subject matter of today's talk, which is corruption is never victimless. And so Honorable Rock, you outlined on the back end how individuals would avail themselves of the court's justice through their individual claims, through asset recovery. I'd also like to point out on the front end how we're seeing individuals and civil society organizations, legal constituencies, youth networks avail themselves of international courts in novel ways by advocating first to their states to take advantage of those institutions. We see this increasingly with the ICJ, for instance. We would not have had the historic advisory opinion last year on the obligations of states with regards to climate change had it not been for the momentum, had it not been for the advocacy by youth from the Pacific Islands, who would have maybe thought just a few years ago that this institution in The Hague was far away, was very removed from their lived experience, but saw the existential threat and started by advocating to their governments first to take this issue to the UN General Assembly and then have the first ever unanimous referral to the ICJ. We can certainly see similar victim and survivor-centric networks forming to advocate to their states to bring a question before the IACC. And then lastly, would love to talk to our Ghanaian colleagues. We have some wonderful connections within Ghana, but that is why talks like this, discussions are so important. You've obviously had a wonderful trajectory before the ICC, first with the last prosecutor. Now you have a candidate who's a good friend of mine as a judge before the ICC. So would definitely love to continue this conversation.
Thank you so much. Serena has had to leave us. I think we have time for one more round. Let me take a quick look at the questions online and also invite more from the room. There's a question from Marina Zarubin saying, given some of the issues on national levels that were mentioned with enforcing anti-money laundering, anti-corruption legislation, what are the safeguards you propose that the court would have which would prevent these issues also appearing at the supranational level? She suggests Judge Goldstone, but it is also open to other panel members. Vijil Kanitara says, on behalf of the All India Sustainable Development Council, how can the proposed IACC ensure accountability when corruption directly harms indigenous peoples? Mentioning illegal resource extraction, manipulation of land records, or diversion of development funds intended for those communities. Rohan Vojdani is curious as to the consideration given to the court bench and whether a judge from the relevant nation under investigation would be able to sit on the bench, or will these cases be decided devoid of that alleged nation's involvement in the judgment? And finally, another question about who would have access to the court if ordinary citizens or other actors are unable to trigger its jurisdiction. Might that somewhat limit the court's effectiveness? How would jurisdiction be activated in circumstances where states are unwilling or unable to act themselves? I hope I've done justice to your questions. Let me ask for any other points from around the table before we turn back to our panelists. Yes, please.
I'm Dr. Sefu Ntengman, and I work with the Ghana Anti-Corruption Coalition. I want to find out how the courts will be funded in terms of their activities, and also how they are going to report on the various cases that they are handling, and how the public can also assess such reports.
Thank you for that important question, which was also on my mind. Last chance, anyone else around the table? Yes, please.
I'm curious about the overlap between the IACC and the Foreign Corrupt Practices Act of the US, which allows prosecution of individuals and corporations.
Which is a domestic instrument here in the US.
But has wide territorial reach.
Right. Panelists. Judge Goldstone, may I turn to you first?
Right. Well, thank you, Corin. I'll try to answer a couple of the questions. The first one is that obviously it's very important that anybody with an interest is entitled to come to the prosecutor of the IACC and request an investigation. The prosecutor doesn't have to rely on authorities from the state that is alleged to have corrupted its officials and laundered monies. So that's important, and certainly for people in autocracies, in kleptocracies, are often silenced in their own countries, but the IACC will give them voice at an international level, and if the monies have in fact been laundered in a country that's a member of the IACC, the court will be able to lay its hands on them. I stress that, as we've already explained, the court will be complementary, and the first bite of the cherry will obviously be allowed to the countries concerned. But when you're talking about kleptocrats, they don't do anything, and it will be an international anti-corruption court that will do so. Thank you for the very interesting question as to whether a judge from the country from where the monies have been stolen would be entitled to sit in a case involving his or her country. Frankly, it's an issue that we really haven't grappled with. In my own view, it would be inappropriate to have a judge from that country sitting on the court. I don't think the system of ad hoc judges has worked particularly well or effectively in the International Court of Justice, and this is something, though, that our experts and obviously the governments we're consulting will have to decide. As far as funding is concerned, the IACC would have to go the same way as the International Court of Justice or the International Criminal Court, and rely on funding from countries that join the treaty to set up the International Criminal Court. The court would have an additional access to funding, and that is fines. The International Anti-Corruption Court would be able to not only put people away in prison if they found guilty of kleptocracy or facilitating kleptocracy, but they could also be fined, and there could be very huge fines could be implemented against these people, and this, I'm sure, would be an additional source of funding. I would stress that the monies that have been stolen will in no way be used by the International Anti-Corruption Court. those monies belong to the people of the country from where they've been stolen, and they will certainly not form any part of the funding of the funding of the court. Finally, as far as the Foreign Corruption Act in the US is concerned, it's a good example of domestic courts working very impressively, certainly until recently. Unfortunately, the present Trump administration has weakened seriously the efforts of United States prosecutors and investigators to investigate corruption committed or attempted by United States citizens. But in no way will the court interfere with those sorts of domestic operations, and especially where they're efficient and effective. Thank you.
Thank you very much. Casey.
Yeah, just to answer the last question on the Foreign Corrupt Practices Act. This is a topic that is near and dear to my heart. You can read all about the history of the Foreign Corrupt Practices Act in my forthcoming book. Please get all your pre-orders in now. I have to say that so my publisher is happy. It's a great question because
What's the title of the book?
Oh God, sorry, United States of Oligarchy. How could I fail? This was legislation passed back in the 70s in the aftermath of the Watergate hearings and a number of other things that revealed the rot at the heart of, at that time, America's corporate establishment in these massive bribery rings around the world, in Saudi, South Korea, Honduras, Netherlands, Italy, the list goes on. And the ethos of that act was that at the time then, and certainly you could argue now, that it was the United States' right and responsibility to prosecute corruption that is taking place elsewhere, outside of the United States, even if it involves an American company or a company listed on an American stock exchange. And you can trace a direct line from the ethos of the origin of the FCPA, even though it's only been enforced in fits and starts, and of course is shambles now, but the ethos of that to where the IACC is now. Corruption is being allowed to flourish somewhere. Someone needs to do something about it. Now, the other lesson of that, again, which Justice just mentioned a moment ago, is that the risk is for something like the FCPA, if you have an executive that demolishes any distance between the White House and the Department of Justice, then suddenly the FCPA becomes his plaything. And there's nothing anyone could do about it. We're all that much worse off for it, which gets to, again, one of the beauties and advantages of the IACC is that it is not left in a single executive's hand or a single nation's hand. Putting all your eggs in that basket can turn quite quickly, which is why having something like the IACC, not only as a backup, but as a leader for this, reduces, doesn't eliminate, but reduces some of that risk itself. And I hope the FCPA regains the momentum it once had. It remains a case study in success. We've seen replications elsewhere, but it has proven over the last 14, 15 months not to be something that you can rely entirely on for the foreseeable future.
Thank you for that. It also leads me to wonder where this IACC is going to be based in the world, because it will make enemies. Alan.
Two things. First of all, on the Foreign Corrupt Practices Act, as Justice Goldstone observed, the American government has suspended its application for the moment. The good news is the statute of limitations is 5 years. So if the League of Women Voters is capable of getting those 90 million people who didn't vote to the polls next time, it's a change in government. But there still might be time to bring prosecutions under that statute for deeds done now. And that's something to look forward to. The other thing I want to touch upon is the question about Indigenous persons, because that is all too common and a tragic occurrence that Indigenous persons are victimized by extraction companies who come onto their land, destroy it, take the resource, exploit it, and put the money offshore. So let's imagine a case in which there's a country which is rich in resources, one kind or another, and an extraction enterprise comes to that country, pays significant bribes for access to the resources, causes environmental damage, extracts the resources, does not pay any royalties to the indigenous people who occupy that part of the country, but then they leave. The International Anti-Corruption Court will operate on the principle of complementarity. In other words, if the country in question is willing and able to launch its own investigation and prosecution into alleged wrongdoing in all of that, then they will. And we respect the sovereign right of that nation to undertake its own investigation and prosecution. The IACC is there for situations where the country in question is either unable or unwilling to do that. Unable because they don't have a court system, or they haven't got a police force capable of the investigation, or unwilling because they're all on the take and nobody wants to do anything about it. That's where the International Anti-Corruption Court, acting on information provided to it, would launch an investigation and be able to prosecute. Now, if they prosecuted and they were able to, say, freeze the assets in Switzerland that were deposited there by the corrupt country, the company that took the resources out of the ground, then at the end of the prosecution, if there was a finding of guilt and a conviction, the money in Switzerland would be able to be used to recompense those who were damaged by the wrongdoing. And the Assets Division would be working in tandem with the Criminal Division to effect that purpose. That is, just imagining, that is the way it would work, that the court would be there if the state in question was not itself going to investigate and prosecute, that the court would use evidence it gathered to launch the prosecution, hopefully succeed in a conviction. Any assets that were identified that were proceeds of the corruption available for distribution to those aggrieved, and the indigenous groups would be entitled to come before the court and make their case that they were entitled to part of the proceeds. That's the way that one would imagine it unfolding. I think that's all I wanted to say about that.
Thank you so much. Rebecca, you have the last word from among the panelists.
Well, I think I'd first like to piggyback, segue from Honorable Ruck's comments on the rights of Indigenous persons as foreseen not only in the statute of the IACC, but in its foreseen practice, which will of course be extrapolated by its judiciary and also by its prosecutors. So we have seen, not fast enough, but I think in accelerating in international law, acceptance of the rights of Indigenous persons as specialized. We're here talking about, and this is a comment that Serena made in her opening remarks, we're here talking about gender, but we're also talking about the rights and obligations to other vulnerable or marginalized communities. And here we see Canada, of course, leading at the vanguard of acknowledging that Indigenous persons and communities have special duties that are owed to them and face special vulnerabilities in situations like these that we're talking about today of corruption. So where I look to the ICC for inspiration, for example, is in the promulgation of strategies by the Office of the Prosecutor. This past year, we've seen the first strategy ever on environmental crimes and cyber-enabled crimes. There have been strategies on women and children, and there is discussion of a strategy on how, when, and how robust a consultation, prior consultation with Indigenous communities needs to be where they are deemed to be effective. I would hopefully see such a development within the IACC, not only by its prosecutor, but by its judiciary as well, and looking to those progressive elements of both domestic jurisdictions, regional courts, including the Inter-American Court and the African Court for Human and People's Rights, which have had quite groundbreaking jurisprudence quite lately on that issue. And then I think the only other question that we might have failed to answer, I'm just trying to, since I've last play catch a little bit here, was with regards to SDG 16 and the significance of the IACC there. So obviously the spirit of, and I can't remember if that was asked online or in the room, was it in the room, online? So the significance of the IACC with regards to SDG 16, I think is profound. This is fulfilling a fundamental gap when it comes to access to justice, when it comes to the interrelationship between international courts and tribunals, between domestic systems and a global governance architecture that supports the rule of law over this crime for which persistent impunity remains. And I'd also like to put out that the SDGs kind of fed into this process that we've witnessed throughout, that some of us in this room have been quite close to in the lead up to the 2024 Summit for the Future and the Pact for the Future that was disseminated therein, where we're now in an implementation phase. And while the IACC was not mentioned explicitly in the Pact for the Future that was promulgated by states, I will give a shout out to one gentleman named Dan Perel, who led a People's Pact for the Future, which is a civil society accompaniment to the state-led pact that has been promulgated and disseminated. And there are some of us ensured that the IACC did make it into Chapter 2, Peace and Justice. And so as we look to these UN processes playing out across the street, playing out often in this room or in similar chambers around the neighborhood, I think it's important to bear in mind these existing linchpins, whether it be SDG 16, whether it be the Pact for the Future, and all the various action items that are contained therein, and look to these as lodestones to feed into current state areas of prioritization and framing devices.
Thank you so much. Yes, this connects to a lot of commitments that are already there. And before I turn over to the aforementioned Daniel Perel, the representative to the UN of the Baha'i International Community, I just want to pay tribute to the extraordinary enthusiasm and vision that has brought this far. And now we need more push, more partners, more champions to take it forward. So thank you, and Dan, over to you.
Excuse me. Well, thank you very much to all of you for joining us today, and particularly to the colleagues at III. I think this work is phenomenal, not only in terms of the structure that is being built, the way that you articulate it, but also that it is such a clear expression of the values that we all hold so dear, translated into an institution that could offer some solutions to some of the greatest problems facing humanity. So of course, I'd like to commend and express my gratitude for the clarity of this proposal, the substance that was shared. To say it's compelling is an understatement, but this shouldn't be particularly surprising considering who is behind it. Folks who I read about during my own law school studies 15, 20 years ago, and to whom I and many others are most grateful for their pioneering work. So I really don't know how to summarize what's been shared, but maybe it's through a small story, which is that years ago, I asked a friend of mine who lived in a country that shall not be named, what his life might be like if he trusted his government. It knocked him off his chair. He sat there in silence thinking. 15 minutes later, he said to me, Dan, I've been thinking about that question and I have no idea what it would be like to live in my country if I trusted my government. And I found that very sad, because government should be at service of the citizen. And I think this idea of corruption is one that is an expression of that gap between the citizen and the leader. But then I was thinking, why is it that people are corrupt? What leads them to this? And it seems to me that there are three assumptions that drive this narrative, that forces sort of the hand in this direction. One is this idea that there's a hierarchy of people, that one group is somehow more important than another. And that can find expression at a very micro level, where one individual justifies the stealing from another, and also at a macro level, where one nation can conceive of itself as exceptional. Another of these assumptions is that success is defined as accumulation, whether it's accumulation of power or of finance. If we continue to think that success is more, then corruption actually is a logical extension of that. It's just another way to be more successful. You get more. And then a third assumption is that these short-term or quick interventions are more important than long-term approaches. That we need a quick fix to solve this problem today, and then we'll deal with tomorrow. This assumption leads us to creating structures and policies that don't conceive of future generations or the impact, the negative impacts of those decisions we take today. And when you combine all of these assumptions, you get corruption being almost normalized. It's a natural outcome. So then how do we change that new set of assumptions? And I think, or how do we change that old set of assumptions to what I think most of us in the room would agree should guide humanity today? And I think there's an interesting conversation between institutions and individuals and communities. And when you're proposing an institution like the IACC, you're actually inviting a conversation about the values that need to underlie society at this moment. And so it is about the institution that we're talking about, but it's also about bringing this conversation to the fore about how we can overcome corruption in our leaders. So I won't get into more. I think I've perhaps already overshared, but I will say, what do we do from here? Well, first, to me, it's seeing this effort as an expression of justice. That is an opportunity for community to express its own freedom and to conceive and pursue its own path of development. This is true justice. And where corruption occurs, it actually constrains a community from advancing its own aspirations. So for me, my own call to action will be to certainly check out that website once again, which I promise I have been following. It was put in the chat box, but for those in the room, it's iaccourt.org. There are a number of ways to get involved. I'm not an advocate, I'm not paid for by them, but I will say that this is one of those very clear examples of a thing that can have such profound change that actually all of humanity can get behind. I don't think anybody would say yes to a worldwide community that allows corruption. I mean, that's just not, like, you put any leader on the spot and say, should your country be corrupt? Nobody's going to say yes. In fact, many of those leaders that we've been speaking about here, who we might identify as corrupt, got to that position of power because they named their previous administration as corrupt. So corruption is in fact a political tool that we're using. And so why don't we find a way to sort of make these commitments good in the future by continuing to encourage our governments to endorse the IACC. And I look forward to another one of these meetings 1 year hence, where we have more countries, Ghana's and the others of the world who have signed on and are looking to continue to advance this. So once again, thanks so much for coming today, and thank you so much for the work that's gone into this amazing project.
Thank you.